All right, so listen, thank you everybody for being here. This is a very important meeting. They're all important, but this is especially important. We have a very prominent guest speaker, somebody that all of you know, if you've been around this space for any length of time at all. Let's start off, as usual, just for some of you who, because I know we have hundreds of people on the call today, and some of you, it might be your first time. The mission of US Inventor is to restore to inventors and startups the rights that the Constitution says that we should have. We should be able to exclude other parties from your patented invention, no matter how powerful those other parties are, no matter how much they just have to have your invention. You should be able to negotiate with them at arm's length. And if you want to compete with them and not let them even touch it, you should be able to do that. They should have to out-innovate around you. They should have to out-innovate you. And this is what made America the most innovative country in the world, which helped us lead the world, stay ahead of our adversaries. That's a key factor right now. Our adversaries are looking very dangerous because we're not out innovating them like we should be because of what we've done to our patent system. So anyway, that's the mission of US Inventor, and we're working very hard to accomplish that. So there are a couple of disclaimers I want to give you before I introduce our guest today. One is that anything you hear on this call or any call we have is not to be considered legal advice. Even if it's coming from an attorney, even if it sounds like legal advice, it's not legal advice, okay? Go to your attorney and pay for legal advice, but what we're giving you is not. The other thing is we have a number of people who are panelists up here. I call them panelists. They're basically going to be asking the judge particular questions after he finishes his statement. And these are individuals, even though they're members of US Inventor and some are officials, whatever they ask or put forth is not to be considered any policy of US Inventor. This is going to be from them as individuals, their own thoughts. We will be issuing US Inventor policy regarding this legislation that we're going to be discussing in a few days, most likely. But whatever you hear today is simply an effort to gather all the facts in our effort to formulate our own decisions and what policy that US Inventor is going to pursue regarding this legislation. The legislation is the Patent Eligibility Restoration Act. And by the way, guys, today we have hundreds of members, hundreds of people on the call. We have senior members of the Judiciary Committee and other offices in the House and Senate. We have senior executives of the USPTO on the call. We have members of the media on the call and an awful lot of very interested parties, whether they're inventors or startups or attorneys. So this is a big effort to answer questions, to look at this legislation and to really get the issues out. And by the way, any of you who are not up here as panelists, you can submit questions through the it's not the chat, it's the
Q&A feature.
Cassie, what? Say it again.
Q&A feature.
The Q&A feature, and we'll try to get to as many as we can, but we'll do our best. Okay. So our guest today is former Chief Judge Paul Michel, and Judge Michel was the Chief Judge of the Federal Circuit. Very prominent figure, very well known in Washington, D.C. on our issues. And Judge Michel was involved with the 101 Taskforce in helping put together what we're going to discuss, which is the Patent Eligibility Restoration Act, which is referred to as PERA, P-E-R-A. And I think I'm just going to go ahead and give the floor to Judge Michel, and then we'll ask you some questions about it. So go ahead. And thank you for being here.
Thank you, Randy, and thank you all the members who are tuned in. It's a privilege for me to have a chance to talk about such an important issue with such experts in invention and patenting and patent enforcement. I should say a little bit about my own motivation. I retired from the court in 2010, primarily to be able to speak out on steps needed to revive the strength of the US patent system and other IP rights. It was already clear even a year before the AIA was enacted that there were serious problems going all the way back to the eBay case in 2006, and they were getting worse. KSR in 2007 and on, the rest of the story. Now, of all the problems that have cropped up, in my opinion, the single most harmful problem is the impact of 4 Supreme Court decisions in the prior decade on the scope of eligibility allowed under Section 101. The court basically rewrote Section 101 to its own preference rather than following the rather clear terms Congress put in the operative language of that fairly brief statutory provision. So it deserves a lot of attention. The problems of eligibility are basically twofold. One is it's confused, it's unpredictable, it's unadministrable, it's unworkable, it's impractical, and I could say other negative things about it. And they're all true in my view. So serious reform seems an extremely high priority. And I've spent a lot of time in the last 5 years working on eligibility reform. The courts have ruined eligibility law in America, starting with the Supreme Court, but the Federal Circuit didn't help either because they seem to, in some respects, extend the reach of the quartet of Supreme Court cases. Of course, we know that's Bielski, Myriad, Mayo, and Alice. But I think the Supreme Court is overwhelmingly the source of the trouble. They did a number of things, but 3 stand out to me as the most harmful. Number one, they ignored claim limitations in deciding eligibility. It is a total no-no in patent law. Every limitation counts. You have to account for all limitations in making any assessment of validity of a patent. Secondly, the court grossly conflated considerations under 102, 103, and 112 with the analysis of 101 eligibility. Another clear no-no. If you look at the Deere case, it was specifically condemned by the Supreme Court back in 1981, but they started doing it again anyway in the quartet of cases. The third fundamental defect in the Supreme Court's approach is they insisted on using vague, subjective, unbounded terms like abstract with no hint of what abstract meant. And of course, in Alice, they specifically refused to give any color to what was intended in Mayo and Bielski by the word abstract. So those to me were the worst of the ill designs by the Supreme Court. And the final word about the Supreme Court is, in more than 60 occasions since the Mayo case, which I think is probably the worst and the most seminal of the 4, they've refused to revisit their Mayo doctrine. 60 cert petitions have been denied in the years since 2012's Mayo decision came down. So my conclusion is the Supreme Court won't fix it, not interested in fixing it, maybe doesn't know how to fix it, unwilling to get involved again. The Federal Circuit, of course, is largely trapped, not 100%, but largely trapped by the 4 Supreme Court cases. So I came to the conclusion some time ago that only the Congress could rescue the system from the impact of the bad decisions on eligibility. So I've been working very hard on that. I should be candid to say that I'm not really the main leader of what Randy is calling the task force. That's even too elegant a label because it's actually just a very loose association of about 70 stakeholders from diverse business models, diverse technologies, and so forth. But the group was put together by Dave Kapos. He recruited me to help try to steer it a bit, which I agreed to do. And I've been working closely with Kapos ever since about 2018 on this. But he really has been the main leader. He's had a lot of help from very talented people and a lot of cooperation from people who are on this call, such as Paul Morinville and Josh Malone and Ron Katz-Nelson and no doubt others that I'm not going to try to fully identify. So what have the impacts been? Well, the Federal Circuit has handed down a series of decisions that to me look just crazy. So for example, a garage door opener, ineligible. A digital camera, ineligible. A drive shaft noise suppression system, ineligible. And you know the rest. There are at least a dozen cases. They all sound crazy to me. They all do exactly what the Supreme Court did. They ignore claim limitations. They import considerations under 103 and 112, et cetera. So the Federal Circuit's been no help either. The other thing to say, the last thing I'll say about the Federal Circuit is, just as the Supreme Court has refused to grant cert in any 101 case, the Federal Circuit has refused to go in bank on any 101 case, even though they have 101 precedents that are inconsistent with other Federal Circuit 101 decisions by different 3-judge panels. So that's another reason why I had to give up on the Federal Circuit, just the way I gave up on the Supreme Court. So Congress is the only realistic agent to fix this problem. The goals of the reform bill are meant to fundamentally address where the Supreme Court went wrong. So the bill tries to make it clear that the Supreme Court cases are abrogated. The analysis that they embody is disapproved and rejected. Secondly, the intent is to exclude the courts from repeating the same kind of errors they made in recent decades by making it clear that Congress wants clear lines and they're not to transgress the clear lines. Now, one other thing that could be said about the reliance on Congress is, first of all, it's their statute. Secondly, it looked pretty clear on its face, and the Supreme Court just disagreed with it as far as I can surmise. But in a democracy, big policy decisions on innovation economics clearly should be made by the Congress anyway, and not by unelected judges. So there were just so many problems, and Congress is the answer. Now, the strategy of the bill was to try to make everything eligible. That's step one of the analysis. Everything is eligible. Of course, it has to be in one of the 4 classes. It has to be a process, a machine, manufacturer, or a composition of matter. But anything and everything that falls in one of those 4 classes is eligible unless specifically excluded by a short list of exclusions in the bill, as you no doubt know and have read. And some of them are not so tricky, but the tricky one really is the word process, or art, as it sometimes was called in former times. And so we ought to be particularly clear on whether the intent to make almost everything eligible, with a handful of very narrow exceptions. We have to look at how it was done in the act, because it's not so clear if you just quickly read the language. So after the initial findings and some of the background provisions early in the bill, the critical provisions are on page 6 of the bill, which is where the exclusion list occurs. And the 2 things to note are that if something is, quote, substantially, and that's of course a key word, but well known in legal usage, not technological, then it's going to be eligible. And to be even clearer, the B2 provision says a process, even if it is in one of the excluded categories, is still eligible. This is the key point, is still eligible if the process, as a practical matter, cannot be carried out without a machine or a manufacturer. So for example, if the iPhone or a desktop computer is necessary as a practical matter to carry out the process, then it is eligible, full stop. And that's easy to overlook. And I think it's really critical for us in our discussion to focus on that. Now, of course, there's concern that, well, can you trust the courts? Well, at a certain stage, there's going to be litigation and there's going to be some interpretation of words if they're significantly ambiguous. So the statute tried to draw very clear lines and use unambiguous words. The prior version had the word non-technological in it. And we worked for months and months and months to try to give that a meaningful definition, and it failed. So we took that word out and substituted what's really a safe harbor. This is the provision goes under B2I. And that's the one that if you need a computer to do it, it's eligible, even if it looks like a business method or it looks like any of those other things listed in B1. Now, the practical impact of this, in my opinion, is no invention held eligible by the courts under the current law will become ineligible under the statute. It's a one-way street. It only expands eligibility compared to current law. It doesn't shrink it. So, for example, all these cases like American Axle, the axle noise suppression case, are eligible under the bill, even though they were held ineligible under the former awful judicial case law. It was very important to recognize that it's a one-way street that expands eligibility, and nowhere does it shrink eligibility compared to the current law. So the bill, of course, like any bill, can be criticized at detailed level or at a more general level. That's always true. I don't deny it, but you got to remember one thing. We had a bill way back in 2019 that Tillis was going to introduce, and then he didn't. So in June, we had 3 days of hearing, 45 witnesses, 41 of them agreed the law is a mess. Even the ones who wanted to avoid reform agreed the law was a mess. Even Mark Lemley said the law was a mess. So the witnesses were lopsided. It was basically, all 44 out of 45 witnesses said something needs to fix this mess. And Tillis was committed to doing it. So then what happened? Between the hearings in late June and August, he backed off and didn't introduce the bill. 2 reasons. The main reason, which he publicly emphasized, is that it became clear to him that the pro-reform group, our group, was internally divided, and not all were supportive of the approach. And the second thing was there was massive, massive lobbying, just as we all knew there would be, from the High Tech Inventors Alliance and the American Civil Liberties Union and the big retail chains and some big New York banks, and from other sources, including, importantly, a lot of famous scientists who said this was going to kill scientific research and result in professors and researchers being charged with infringement, et cetera. So from August 2019 until last month, we were working to get the bill made viable in terms of the politics, something that Tillis would actually introduce when he had withdrawn support before. And secondly, to try to get it to be bipartisan by finally convincing Senator Coons to join. It took months and months and months. So we finally got a revised version of the bill that Tillis was willing to introduce in 2023, did introduce, and Coons publicly committed to being an original co-sponsor, and he did sign on and serve as an original co-sponsor. And of course, it's also in the House. So it's bipartisan with key leaders, and it's bicameral in the 2 relevant IP subcommittees of the 2 bodies of Congress. So that's huge progress. Now, when we say, well, I'd rather have this line or that line in the bill different from what it is, we have to deal with, what is possible. And if we don't have the support of our limited number of champions, particularly in the Senate, we're nowhere. We're stuck indefinitely with the horrible case law from the Supreme Court and the Congress. So this bill, and we spent a lot of time working with Tillis and Coons and others and their staffers at every level to try to test, how big a problem is it for those politicians if they back X, or if they back Y, or if they don't do Z. We tested that and tested that and tested that. And in the end, we concluded that this bill, as it's currently worded, number one, will work well. And number two is the best that there's any chance of getting to move forward. Remember, in the 2019 hearings, not a single Republican other than Tillis himself even attended the hearing, much less supported the effort. And on the D side, it was a draw because Coons was supportive along with Tillis, and Hirono was also supportive, but Blumenthal was against it. So to my reckoning, Blumenthal and Hirono canceled each other out. So you basically have the D leader and the R leader at the top of the committee for reform and nobody else supporting them. And that's still largely the case. So in order to move a bill forward, to get hearings, to get markup, to get it to the full committee, to get it through the full committee process, you got to build up a lot of momentum. And that's what we're trying to do. And I'm absolutely convinced that Tillis and Coons will not abandon the ship. They'll fight this thing through, but it's going to be a long, hard slog. It could very easily take several years. It might even take longer. No one can say. So let me stop there, Randy, because I think that lays the basic groundwork for a more, active interchange and discussion. So thanks, everybody, for listening.
Well, thank you, Judge.
Let me make one real quick comment to all of the viewers. There's a lot of comments here on the American Invents Act. This particular bill has nothing to do with the American Invents Act. This is all about patent eligibility. It has to do with 4 Supreme Court cases. We will have another Zoom call later on the American Invents Act and the PTAB.
Yeah. Yes. Thank you, Paul.
Randy, can you hear me?
Yes, I
This
can.
is Ron.
And actually,
Okay.
Ron, I'm going to let you ask questions first.
No, I
First
just want to
is-
check. Go ahead. Make the
Yeah, but I first
introduction.
wanted to say to our members, so these panelists that we have up here, almost all of them have been through litigation, most with 101 challenges, representing hundreds of millions, if not more, in potential damages. So this is a very serious group of questioners we have. So go ahead, Ron, take it away.
Thank you, Judge Paul Michel. And this, in a way, my questions will follow up some of the private emails we had communicated over the weekend. I appreciate your help. And frankly, your contribution in the task force to really improve what was there before a substantial way. I cannot be more supportive of the effort, although it does leave quite a few questions in our minds. So the first question has to do with safe harbor. The exclusions, which is process substantially economic, financial, business, social, cultural, or artistic, unless the process cannot practically be performed without the use of machine or manufacturer. That safe harbor is a problem in the sense that it does indeed salvage quite a few cases, but it decidedly is highly problematic for algorithms, analysis procedures, classification methods, or strategies, all of which a party could argue could be reduced to doing it without a machine. If I can identify on a piece of paper and pencil what the algorithm is and perform it, then it doesn't have to be using a computer, and therefore it's ineligible. That's one of the major holes that in here, per se, are ineligible. And I'm seeing that as a serious concern for many, many cases where people have algorithms, analysis procedures, and things in areas that are financial and business and part of the service industries that this country is really needs to excel in. Those are taken away for sure by statute. And the practical, what is practical is a real question of fact, I think, and it will open up a whole new can of worms, necessitating the other elements of the bill, which we haven't discussed, and that is the discovery, which is never really done today outside of the regular discovery under Rule 26. So on that particular issue, is there a policy articulation? There's nothing in the findings of the Act that explains why some of these exclusions are made. What is the policy those who really wanted to exclude is being advanced here? What public policy would essentially deny patentability or patent eligibility for algorithms or analysis procedures for economic, financial, business? What is the policy that has been articulated by those who want to exclude it?
Well, Ron, if an algorithm or any other ingredient is a part of a claim to a process, it is eligible.
Not if it can be performed without a machine.
Well, that's not quite right. If doing it by hand, by pencil and paper, would take too long, which is an extremely common situation, it is eligible. So, for example, the trading technology patent that was trashed on eligibility would be eligible under this bill because the computations have to be done fast to meet the goal of the process. And that would be true of a great many inventions. So the idea that something theoretically could be done by a human if he had 1,000 years to sit there and do it with a pencil and paper, that's out the window. That's not practical because the context is a need for speed and also a need for memory. I don't know about you all, but my memory isn't perfect. If I'm doing an extremely complicated problem, I can't retain calculation 1 when I get to calculation 200. So even aside from speed, if memory retention of a human with a pencil and paper is going to be a problem, then it's eligible.
Yeah, I understand that. And that's true for many, many cases, you're right. But the most interesting aspects of algorithms is that they're somewhat simple. And instead of taking 5 milliseconds, they may take 5 minutes, but could still be practical. The catch issue here is that there's a whole swath of processes that can take 100 times longer, technically, by hand and paper. And yet that is the invention. That is the value added. And the fact
One
that
brief point of clarification while you're on that topic, because Judge Michel, thank you for your time. You mentioned using a pencil and paper, but when I read the statute, it would provide eligibility if a machine or manufacturer is required to practice the invention. Why wouldn't a pencil and paper bring that back into the scope of eligibility because it is an article of manufacture?
Well, it runs against the logic of the bill. The logic of the bill is, number one, every process is eligible, except if it's cultural, to take an easy example, or artistic or aesthetic. But even then, it is eligible if the process couldn't be done as a practical matter without the use of a machine.
It says machine or manufacturer is my point.
Sure, but that's because it also has to cover things in the biotech world.
Yeah, I understand. But I think what Josh is raising is even the concept of what is the scope of practical as far as manufacture is. If every element I use is not a machine, but elements of manufacture, it's just like a paper and a pencil or a pen, and I use it in exercising the algorithm. The algorithm could be very simple. Let me give you an example. The
Ron, I
binary
don't
to
think the
BC
simplicity of the algorithm is a factor.
well, but it should be
The
patentable
question
even if
is
it's
whether
simple.
the process that utilizes the algorithm can only be done with the aid of a computer or
That's
some
exactly the
similar
point.
device.
That's exactly the point. Algorithms are typically the inventions, not the way they're implemented. For example, the binary to BCD can be done on an algorithm piece of paper, and I could give you the answer how to present a binary to BCD number based on that. And then that process cannot be patented today because it's an algorithm that can be done without a machine. So there are many cases, and we will probably list a whole bunch of them, where algorithms that have been recognized can be done without a machine or manufacturer are not going to be eligible. So there's no question that many things are salvaged here. And to that much, we got to give credit to the group of trying to salvage things that otherwise would not have been salvageable. But there's still a very broad element. And I still don't get the policy reasons. If those who propose these exceptions can articulate a policy, why algorithms in economic, financial, business, social, and other areas. For example, if there's an algorithm to run a social network platform being invented, it could be shown to be done in 10 minutes to be able to decide what happens to a member rather than 5 milliseconds, why would that not be patentable? What's the policy guidance that excludes those areas? That's really the questions we have.
Well, as I said, there's a broad understanding that goes back to the start of the country that the patent system is essentially directed toward things in the realm of technology, not in the realm of musical composition or oil paintings or other things far distant from technology. But in the earlier bill that was introduced by Tillis alone without Coons last August, we used the word non-technological, but it couldn't be defined despite enormous amount of effort in a way that worked. So we had to find a way to observe this basic division of human activity between the broad technological realm and the plainly non-technological realm that didn't depend on defining the word non-technological. So this series of provisions is designed to do that. So that's the policy behind it, that the patent system isn't meant to cover everything. It's meant to cover things that touch on technology.
Let me add one quick comment to Ron's discussion of algorithms. All artificial intelligence is an algorithm, and this has risk of making artificial intelligence in any one of those categories unpatentable, which is an extremely bad problem to have, with China now ahead in 37 of 44 different technologies. But I see that as, you can do that on pencil and paper. You can't have it patented.
Well, we don't even get to that in my view, because if it's part of a process, it's eligible. So an algorithm that's not part of a process, like a mathematical formula, a simple algebraic formula that's not part of a process, would not be eligible. But as soon as it's incorporated into a process as claimed in the patent claim, it is eligible.
There's already an exclusion for mathematical equations. So if that's the case, then we don't need this provision.
Well, there's an exclusion for mathematical algorithms to try to help make clear the distinction between things that are a part of a process and things that only exist in the ether, like a pure mathematical formula.
Yeah, I gave an example of the binary to BCD, which is the early case that was used. And of course, one would try to claim it in a machine, in a system, in a computer, implementing it. But a party could argue, I can exercise the claims, which are process claims. I want to have a process claim. And if those process claims can be implemented without a machine or manufacturer, then it's not eligible. But BCD, binary to BCD, if you claim it as a process, they take this bit and do this and turn out this digit and so on, it's a process, will not be eligible if claimed as a process.
Ron, I don't think that's correct. You certainly are right that lawyers can argue anything, and they will argue anything, but they won't win. That's the point that we should be focused on. So something that's part of a process as claimed will be eligible unless it degenerates to the idea of 2 and 2 plus 2 equals 4 on a piece of paper. If it's at that level, that's not a process. But if that formula, that mathematical operation is put into a process, it is eligible. And lawyers can argue anything they want, but they won't win.
Anyway.
I'm not so sure, Judge. The court decided the word any has exceptions. And the way that I think these courts look at it is they look at a product on the market and a patent holder. The product on the market is commerce. And the patent holder they view as a monopoly, and they side with commerce. They side not to remove the product. And I have really very strong concerns about that particular issue. Can you think of a way that this could be amended to solve this riddle?
Well, I don't know that there's a riddle that really requires some change, Paul, because the reality is that the bill excludes the courts almost 100%. And it can't exclude them actually 100% because the bill has to use words. And words, if they are ambiguous, are subject to interpretation by courts. And you can't get away from that. That's the same problem with claim construction. You have to use words to describe an invention that isn't verbal. And so the words can be quarreled over by lawyers and adjudicated by judges. But the courts are excluded from practically every opportunity to meddle with Congress's determination here. And that was exactly what the intent of the bill is.
Okay, well, thank you, Judge. The second part was the issue of discovery in the case of eligibility, and specifically made as a feature of the act. There's nothing in the policy or the findings part of the bill explaining why the limited discovery and the ruling on eligibility at any time could be made, and why would there not be reliance on the federal rules of civil procedure and the discretion judges have under Rule 26 to do a lot of things? Why is there a need for Congress to intervene in the judicial conference rulemaking process for civil litigation? This is already.
It's not an intervention. It's a restatement of current law. The judges already have exactly the authority alluded to in this brief phrase. It doesn't change the law at all.
Okay.
It's in there because it's a selling point for the rare case where there's no factual issue at all. And therefore eligibility can be decided by the judge without any sort of factual record being amassed. That's the rare case. It ought to continue to be the rare case, and it will under the bill.
But the bill, I think the issue is the discovery. In case there is a factual issue, the bill offers discovery, early discovery.
No. That's not how it works, Ron. You don't know if there's a genuine issue of fact until you have some very limited evidence. Then you compare the evidence put up by one side and the evidence put up by the other side. And then as the district judge, you ask yourself the question, is this a genuine dispute or is this just lawyer talk and there's no real meaningful dispute? In the rare case where the judge concludes there's no genuine dispute over the facts, then the judge can decide the case early, either on summary judgment or maybe in some cases on preliminary motions. but it doesn't change the law at all.
Well, what about
all-
discovery, though? It specifically calls for limited discovery on eligibility. That means it's not a question that is still a question of fact, and it's something that it allows the parties to discover, frankly, one side. When the patent is presumed valid, it allows them to discover facts to be able to plead ineligibility when the patent is presumed valid.
No,
Yet,
no,
it wouldn't allow
the
discovery.
only thing that the discovery can address is whether there's a factual issue that requires trial.
So what does it mean, discovery? Doesn't it mean taking evidence from experts and everything on the issue and eligibility? Is that's what I
No.
read in the bill?
No. It just restates that if there's a need, the judge has the present authority, which the bill doesn't change, to take discovery limited to the very issues pinpointed by the lawyers for the two sides. The issue being whether there's a fact issue that requires trial or whether it's still in the realm of pure law. In most cases, they're going to be fact issues, and therefore the case will go to trial.
So
Where
does
does it
this-
say what discovery? I'm still confused. For example, if there's a challenge about whether it's practical or not to do it without a machine, that's a factual question. Those challenges cannot be discovered by examining the expert of the patent owner and asking him, why do you think it cannot be done without a machine? That's not part of the scope of discovery that is permitted in the bill?
The discovery that's permitted by the bill is the discovery that's already permitted to judges. There's no change in the scope or basis of discovery or the mechanics of how you work it out. So if the judge needs to have some limited discovery in order to know whether this has crossed the line from pure law to fact, he'll order that very narrow discovery limited to that issue as posed by the two sides. So it's not broad discovery. It's not going to take a lot of time. It's already authorized, and it will be beneficial to inventors in almost every case because it will establish that there is a genuine fact issue, and therefore the judge cannot throw the patent out short of trial.
I understand. Would it make sense to, in the background of the bill or in the explanation, to identify that these provisions, both this provision and the one on the definition of usefulness, are not intended to change the law, but they're just a recitation of the current law? Does that make sense as an explanation? So other courts and other entities like the PTO would not take it as a green light of a real change in law because Congress has now adopted different language.
Of course, it would be useful. And that's the very point of developing legislative history. All we have right now is operative text of a statute, a fairly brief statute on a very complex problem. There'll be hearings, there'll be subcommittee reports, there'll be more hearings, there'll be full committee reports. All of the expectations of Congress will be very clearly set out, and they'll have the clear effect of making judges unable to expand present powers or change present mechanisms of lining up issues for adjudication. So I agree with you. That was a very worthwhile thing to do, and that's part of the plan, but we haven't gotten there yet because first we have to have hearings to get this bill moving forward.
What about putting it in the findings? Because there's a list of kitchen sink problems in the findings that are being solved. If there's an issue like that, why not put it in the findings as part of the statute, part of the bill?
It's not an issue because lawyers who do litigation understand how this works. This is in every case on every issue, there's a threshold issue of, is this something that a judge can decide on his own, or does this require fact finding either by a judge on an evidentiary record for some issues or by a jury on other issues? It's understood by everybody.
So currently, under current law, there's no there's no statutory authorization to challenge under 101 that I'm aware of. You can challenge under 102, 103, and 112. But this creates a new statutory challenge on the facts on a 101. 101's been challenged under a motion to dismiss on the pleadings. I don't know what the exact number, 12B6 or whatever that is. But it hasn't been, it's not authorized as a challenge to the validity of the patent, yet it's used that way. This gives them the authorization, right?
It doesn't change the authority they already have, either for discovery or for adjudication. There'll be some cases, maybe, that can be decided on a preliminary motion. Most cannot. There'll be some further cases that can be decided on summary judgment. Most, I think, not. So most cases will go to trial because they'll be genuinely disputed, truly disputed, not just lawyer talk, real evidentiary disputes that require adjudication, just like infringement and other common issues. This doesn't change anything.
Okay, that's a pretty good discussion on the exception clause. Do you have more other questions, Ron, on like usefulness or anything like that?
No, I think I'll let others ask their own. I think, Judge, really appreciate the answer. And it will give us some more thoughts as to how to address these things.
Yeah, that's a good idea. That's helpful. On the useful, the word is in the statute, and it's been careful. And it's still in the statute, and it's been carefully explicated in certain cases. So it has a very clear meaning. The patent office knows what it means. It's in the MPEP. It's in cases like In re Fisher. This bill doesn't change
which I have to
that
commend
at
you
all.
for. Which I have to commend you for. You wrote it. Thank you.
Well, it was clearly what the logic
Sure.
of the law compelled to be the conclusion of the panel in that case. So it clearly doesn't change the law of utility. It doesn't change how that's understood by the patent office. So it's another status quo thing, but by making it clear that that case law gives context to the single word. It's just a naked word in the statute, one word, useful. Well,
So
lawyers can argue useful means a whole bunch of different things. But when you look at the case law, it can't be argued reasonably that it means a whole lot of different things. It means some very specific things that are set out in the case law. So once again, it preserves the current law and it doesn't increase any risks of anything because it doesn't change anything.
So in examination, if an examiner gives me a rejection saying that my invention is not useful, how do I overcome that? I have to have a person who is skilled in the art write a paper on it, or how do I overcome that?
Well, the examiner has an initial burden because he has to credit the utility unless it appears on the face of it that it doesn't have any potential actual real world use at all. The example people give is if somebody tries to patent a perpetual motion machine, which scientists seem to agree can never be invented, that can't be useful because it doesn't work. An invention that doesn't operate to achieve its stated purpose is not useful. That's the clearest case. But the case law spells it out even better. So, yeah, I think this is not a real problem. This is an anxiety about lawyers and judges making trouble. The anxiety is perfectly appropriate because we've seen all the trouble lawyers and judges and justices of the Supreme Court have made in the last 10 or 20 years. So it's a perfectly rational fear. The question, I think, is does the bill do enough to cabin the courts to the narrowest possible thing under our legal system of interpreting words that remain ambiguous, even if you read the whole statute and you look at the legislative history and you look at the findings, et cetera. So it basically excludes the courts from monkeying with eligibility to the extent of 98%. And the last 2% you can't ever achieve because the statute has to have words in it. And the words sometimes can be shown to be enough ambiguous to require some sort of judicial interpretation. But the bill removes the courts from 98% of anything in the field of eligibility, which is exactly what the goal is. It leaves it up to Congress.
So you mentioned in examination, you don't believe that I would have to hire somebody to write a paper on its usefulness. That's what you're saying, or is that not?
No, what I'm saying is under the case law, the examiner has an initial burden to show there's real doubt about whether the invention would work for its stated purpose and therefore could not be considered useful. He can't just say, I assume it's not useful. You have to prove to me with witnesses it is useful. He has to assume it is useful unless it appears on its face to be very doubtful that it would work.
Why does the bill then say I need a person who is skilled in the art to determine its usefulness?
We're not talking about examination. The bill is focused on litigation. That's where the trouble has occurred. All these 10 or 20 wonderful inventions that were plainly eligible under any sensible law or under the law prior to Bielski and Mayo, that's
So you don't believe
point.
that would be brought up in examination. Then I guess that's the point then. So I don't need to worry about that because it won't be brought up by an examiner and I won't have to hire somebody to overcome that.
Well, I wouldn't think. And if an examiner acts wrongly, you might have to appeal or complain to the SPE or take some further action with the PTO authorities. If the examiner acts badly, there are other remedies. They aren't perfect, but they exist. And I don't think you're going to get bad faith actions by examiners or PTAB members or federal judges or anybody else trying to pretend something has no utility, is not useful, when obviously it is useful.
I have a question, Judge. If in fact the usefulness issue is geared toward litigation, if any infringer would be using, or potential infringer would be using it, therefore, why would this even be in the bill if it's geared toward litigation? In other words, they're using it.
It's in the statute, Randy. It's in the statute. It's always been in the statute. Right in the middle of the text of 101 is the word useful. It has to be useful. If it's not useful, it's automatically not eligible. That's been the law forever. That isn't changed.
Let's move on then.
The litigation is really with the patent office. All litigation on utility really is not in infringement cases because, as Randy said,
Breaking up, Ron.
infringer proves. The issue is examination, whether new examination guideline outside of what's in the MPP will be crafted at the PTO because somebody at the PTO, the fact that there's statute now, new language about what useful means, that we need to write a new set of guidance to the examiners. And those could be more exacting in terms of actual show the usefulness. You have to disclose specifically and concretely what the useful aspect of it, and you may trip because we have new guidance. I think that's what Paul is concerned about.
Well, if some amendment to the MPEP or other guidance for examination is called for, we should promote it. I'm not against that. I'm very focused on trying to overcome the Supreme Court mess with legislative reform. But that doesn't mean it's the end of the story. If things need to be done at the examination level, they should be done. And I'd be happy to help.
But if everything is fine, in the MPP and the guidance is correct, and it's pretty much converged on, and there's no dispute, I have not seen recent disputes about utility, then maybe we should add language to the findings portion explaining that there are no issues except it's a restatement of the existing law.
Okay, so we're running on time here, and Matt and Jeff have not had an opportunity to ask their questions. So please, in the interest of Judge Michel's time, let's let them in.
So Matt, are you there?
Yeah, I'm here.
Yeah. Yes.
Okay, well, obviously this is a very interesting and compelling discussion. And I guess I come at this group as a practitioner. So, I guess I'm the beneficiary of a eureka moment back in 1998. And it's one of those moments where you have an idea and you say, this may be worth inventing. And you get patents and you get your friends and your family to support you. And so I know there's more than 100 plus inventors also on this call. And in the details of all of this, we have attorneys that help guide us through all this. But I come back to, and by the way, just for context, my interest in inventing came back when I was in 4th grade, visiting Thomas Jefferson's home and seeing the inventions there and just cultivating it from there and wanting to become an inventor, and started telling people, I think I want to be an inventor. And that's a pretty bold thing to say, but as you start learning very specific things about some corner of the world that you're involved in, you become potentially a beneficiary of this eureka moment, and it changes your life forever. You can't go back. It's just an amazing thing. So I've had about 20 patents. I've been up to the Federal Circuit Court of Appeals about 10 times now. I've been involved in PTABs and post-grant proceedings and everything. And just about all of those things, half of those came from a non-practicing entity. And that entity sent me up to the Federal Court of Appeals multiple times. And I've been up there as well, protecting our patents. I'm headed there again now. I look at it, let me just go back to one other comment. In one of my visits to Washington, D.C., and as an inventor, I never thought I'd have to get so involved in policy. I just want to invent, right? But we found that that's where we end up, is something about policy catches our attention or makes it difficult. And we're like, what's happening? What's going on? What's happening with the constitutional exclusive right that I thought I had, or I hoped I had? And I was back in D.C. with my 16-year-old daughter, and we were at the records hall, and I point to the Constitution and say, here, these 27 words have brought a lot of gray hair for your dad, but these 27 words, this exclusive right to promote the progress of science and useful arts by securing, for a limited time, securing exclusive right to authors and inventors for their respective writings and discoveries. That's what I cling to. I cling to that motivation. And I read this new bill, and I feel like it's now adding more words where it says, respective writings and discoveries, unless those discoveries are substantially economic, financial, business, social, cultural, or artistic. And I look at that and I say, oh man, there's so much margins in there. Maybe there's sufficient case law to help guide that, but it feels like so much margin. It feels like it's hurting the engine. Mayo, from what I understand of Mayo, is it hurt that engine of saying, hey, we need weaker patents because it may affect future discoveries. And that feels backwards to me. So I guess one question I have, again, just at a high level, what can you tell me as an inventor that gives me some comfort that the margins for interpretation around economic, financial, business, social, cultural, artistic, or practical, what comfort can I have that those margins it's not gonna take another 10 years in the courts to determine what that means, and in the meantime, sorry, I'm out of luck.
Well, first of all, you're the example of the type of individual that the system is meant to serve. It's supposed to incentivize and reward and protect you in your inventive activity. The Supreme Court created a monster in the 4 cases, and this bill is designed to kill the monster. And in my view, it does it effectively, and there's no other way to kill the monster. The status quo is terrible for people like you, and really for everybody on this call. We all know so many examples of worthwhile inventions that were held ineligible and therefore invalid. That's wrong. That's what the bill seeks to erase.
And I hear a lot of banter back and forth of where that may not be so clear. And I guess that's what worries me as an inventor. I look at this and say, is this creating additional laws, or is this restoring some of that economic engine of that exclusive right? One thing I pointed to my daughter was, that's the only time the word right is in the Constitution, is that one time, securing exclusive right for authors and inventors. And I'm not sure that's there.
Well, the exclusive right has to do with injunctions mainly, not eligibility. Our discussion today is really focused on eligibility, which is a separate problem. I've been working for every year since I retired in 2010 to try to restore injunctions as well as fix eligibility law, and more recently to try to fix the PTAB and other defects in the design of the AIA and the operation of the US Patent and Trademark Office. So it all needs to be done. But focusing just on eligibility, the critical fundamental thing that needs to be done is to erase the bad judicial decisions and the phony terms and analysis that they are imbued with. And that's what this bill does. It completely overturns what the Supreme Court did in those 4 cases.
But does it do that? I mean, does it, when you start codifying words like economic, financial, business, social, cultural, artistic, I mean, I can see how you mentioned earlier that the patent law was never meant to cover, art and things like that. But those feel like fairly broad terms, and I'll end my comments here, but those feel like terms with a lot of margin and give me a lot of pause, because I can see how a court or attorneys can construe just about anything I'm working on to fall within those categories.
Well, it maybe could. And the savings clause says, even so, it's still eligible if, as a practical matter, it has to operate in the real world on a computer or with an article of manufacture. That's what saves it.
I think it's what Matt is bringing up is the concept of unintended consequences, right? And unintended consequences are so hard to predict, and they seem to be always worse than you predict. But I want to move on to Jeff Harden. Jeff, would you like to ask the judge a question?
Gotta make sure I'm unmuted. Yeah, this great conversation, and Your Honor, thank you for participating, and thank you for your advocacy in trying to help remove some of the problems that we're facing with the Supreme Court and with basically whatever Alice said. We should not swallow all of patent law. It looks like that's what's happening. I do have some questions, and it's kind of hard to figure out which questions have not already been answered or at least addressed. But kind of piggybacking off of what kind of Matt was alluding to, Sherry Knowles and Anthony Prosser, they wrote an article. It was very, very well thought out on the topic of judicial activism. And by introducing these new exceptions into the bill, previously the bill or the current statute says, any new and useful process, manufacture, machine, or composition of matter. By introducing these exceptions into the bill, how is this not codifying some sort of judicial activism? And really, I think that, isn't it what we're trying to do is basically say, we meant what we said the first time?
Sure, it prohibits the Supreme Court or any other level of court from rewriting 101 as the Supreme Court did in the 4 cases.
Okay, so I guess another question to that would be, how does the bill actually prevent the judicial exceptions from creeping back in? Like, how does it do that? Should there be
because
something that says
it says that there shall be no exceptions except those stated in this bill. So it prohibits the courts from making exceptions on their own, period.
Okay. Thank you for that. Another question I have, we talked about practical, something that is practically performed. What is the definition of that? And could there be a definition be put on it? You mentioned, for example, speed, memory as limits to human ability. How do we define what practically performed means so that we can have some clarity?
It's in the claim. It doesn't need to be in the bill because it's going to be in the claim. If the claim makes clear that it's a process that operates in the real world, not the ether, it's going to be eligible. So some of this requires competent claim drafting, but that's well known by people who do this for a living. So I don't think that's an obstacle.
will this be retroactive then, or is this
No.
only going forward? So
Going
those
forward.
claims that are written in the past then, that don't consider how this legislation is written, very likely will not be enforceable. Is that right?
I don't think so. It depends when the enforcement occurs. If you got a patent 10 years ago and you didn't need to enforce it, now the bill passes, now you're going to enforce it. The forward reaching application of the bill does apply to you because it prohibits the court hearing your case from monkeying with 101.
But you can't adjust your claim language from the past though, and that then means if you have claims that haven't considered it, sayonara, see ya. Is that right?
Well, the requirement of a claim to a process to make clear what the goal of the process is has always been part of the law. It remains part of the law, and it's normally done. I think it's very rare. You know, Justice Breyer, former Justice Breyer, to me just sounded like he was living in Never Never Land and talking about you can't patent the formula MC squared equals E. Well, of course not. No one has ever tried to patent anything remotely like that because there's no point in it. It has no commercial value, and it's not patentable under the most basic understanding of what the patent law is for. But if you have a process that operates in the real world for a claimed function, a claimed goal, that's going to protect you. And when somebody comes after you, this bill is going to prevent the courts in your case in the future from doing what they did do in the past that was very detrimental to many inventors, for sure.
Let me just ask the people on here if there's any, it sounds like Ron has one more question.
Yeah, just
Does
clarification.
anybody else?
Judge, you argue that the claim should do the job, but I can claim until the cows come home in the specific machine that implements my algorithm or the procedure and whatever. But the statute, the proposed statute says, unless the process cannot practically be performed without the use of machine or manufacturer. It doesn't say claims not to be performed. In other words, I cannot salvage an argument that it can be done without a machine just by reciting a machine in the process, right? It is a determination, outside my claim, whether it can be performed without the use of machine or manufacturer. That's going to be an argument in litigation, wouldn't it?
No. But the important thing is the burden is on the challenger, not the patent owner, not the inventor, not the current owner, whoever it is. The burden is to show that it can be done just as well with pencil and paper or mentally as it is through a process involving a machine. And it's going to be very clear in most cases that it's not practical to do it mentally.
I agree in most cases. One can think of now, but I can think of several algorithms which are clearly useful and hopefully patentable that will not become patentable because there can be practical way to do them without a machine. Unless there's a standard, and unless I have to put in the claim that these steps shall be performed in 10 milliseconds, and that's a limitation of the claim, okay, it introduces issues as to what is practical and what's reasonable for people to argue is not doable by a machine or manufacturer.
Well, Ron, I don't think that that's really the case. What lawyers can argue is not really the issue. Lawyers can argue anything. The question is, what will judges do? If the statute draws clear lines, judges won't be able to declare a claim ineligible if it's competently drafted. It doesn't have to say 2 milliseconds. It just has to be clear from the claim as interpreted in light of the rest of the specification that this is an accounting procedure, for example, that has to be used at the end of the day in order to allocate vast amounts of money between thousands or millions of parties. Obviously, doing that in pencil and paper is a non-starter. It'll be obvious from the patent document itself, whether the claim says milliseconds or not, it'll be obvious from the context of the spec what the use of the invention is, what the context is. So I don't think this is a real problem. I think we're making up imaginary problems because we're so paranoid about what courts have done in the past, and rightly so, but we're still making up problems.
The point I'm making, I guess, the point I'm making is that there are financial and business methods of, say, sorting a set of offers. Okay, these are technically an algorithm of the way to sort certain offers. It's only an algorithm, and the machine is really not necessary. But it's the inventive aspect is the way, the order of the offers to come in, the way to sort them, the way to select them. These are all algorithmic. Those types of inventions may not be eligible.
That's I think that that question has been asked and answered, and it's a good question. Let me go through a couple of the comment questions, Judge, before you get off. One of these is from Steve Brockman with IP Watchdog, and I'm going to read the question for you. IP Watchdog article published July 2nd by Michael Cicero discusses issues with clear congressional intent and the language, quote, all judicial exceptions to patent eligibility are eliminated, only being in section 2 findings of PERA. I'm wondering if Judge Michel can speak to whether that could be an issue in the way the bill is currently drafted. And I'll look for another one while you're answering.
I don't think so, Paul, because the bill is so clear that judges are out of the eligibility business. Congress is telling us what's in and what's out. So the risk that's now enormous, endless, incalculable goes down to the minimum possible risk of judges creating the trouble they created in the past. And there are other provisions in the bill that lock this in. For example, they prohibit courts in assessing eligibility from considering any factor that's relevant to 102, 103, or 112. It prohibits courts from dissecting claims and casting aside any limitation. They have to honor every limitation. So it builds in multiple protections against judicial meddling.
Okay. Let me ask another one from Robert Schmidt. Judge Michel, thank you for all your help. Is there any way to quantify practically, for the purposes of better limiting the process described in clause I shall not be excluded from eligibility for a patent if the process cannot practically be performed without the use of a machine or manufacturer?
Well, it's a good question. I don't know. I can't think of a way to define it that makes it more quantitative or more easy to apply. If somebody else can think of it as a definitional solution, I'm sure that it would be looked at by the senators and the staffers and Dave Kapos's very diverse, broad group, 70 different stakeholders. Nobody is saying that this bill is perfect. Nobody is saying that this bill is the way any one of us would have written it if we had a free hand. What we're saying is, if you're ever going to have a half a chance of getting any bill, this bill with minimal changes is all that's going to fly. That's the reality in the Congress. If you rather have the Supreme Court current case law as amplified and worsened, I would say, by the Federal Circuit, okay. If you really think that's what you want, then the hell with the bill. But this bill, as imperfect as it could be in any individual's critique, solves the problem to an extraordinarily high degree in a way that's very effective. And if it's going to be substantially changed, it's going to have no sponsors because Coons and Tillis are going to get off it, and then there's nobody going to get on it.
Okay, so let me switch the subject a little bit to other things. How fast do you think this bill will move through? What's your estimate on hearings and markup and all that kind of stuff?
Well, I think there'll be hearings before this year is out in all likelihood, and probably next year as well. You talk about markups, it's entirely impossible to predict. It depends on all sorts of things that aren't even visible right now. One of the problems we have for next year, 2024, is that the Biden administration seems quite hostile to patents. And that's shown up in many different things they've written and said, and to some extent in the behavior of the PTO. So it may take a change of administrations for this bill to have a better prospect of moving forward. And even then, it's a long, slow process because it has to go through the subcommittee, then it has to go through the committee, then it has to go to the floor, then it has to get passed, then it has to go to the House, et cetera. You all know the process. It normally takes years. When I was a staffer for 9 years at the Senate, they had a mantra. They said, a bill that embodies a new idea, no matter how good it is, on average, will take 5 years to pass. So, it may be that this bill will take several years. I'd be quite surprised if it passed before 2025. And I think it's more likely to pass even later than that. So this is a long, hard road. And I don't want to sabotage the war by trying to have the first skirmish look perfect.
So
Judge,
US Invent, hold on a second. Go ahead, Randy.
But well, I just have a question. Isn't it true that the reason this bill is in front of us as it is because big tech is not opposing it?
Big tech is opposing it. They're opposing any change in the status quo vehemently. And they're claiming there's no problem. They're claiming that it is not unpredictable. It's not impractical. It's not excluding things that should be included. They're saying this whole exercise is a phony. So they're going to fight it like crazy, which they've been doing ever since the summer of 2019 and actually long before then. So of course they're going to battle it like crazy. That's part of the realities we have to deal with. That's part of the reason why I don't want to sabotage our long, hard campaign at the stage one by making the bill unacceptable to our only sponsors, our only champions.
So in the process going forward in the House and Senate, in the past, with the exception of me testifying in the Senate IP subcommittee on 101 on this subject in 2019, I don't know of any inventors that have ever really testified. So we've been, it's often lobbyists and they usually work for big corporations. Do you have any sense on whether or not Congress is going to involve small people who have an actual stake in the fight here?
I think it's about guaranteed. Coons and Tillis are not theorists. They're concerned with the practical economic and R&D effects of our current terrible system. And they want to make the system work well for inventors and enforcers and everybody else who's dependent on patents to get investments, to justify risks, to bring out new products, to improve the human condition, come up with new cures, new machines, and all that. So I'm sure that they're very interested, not in what lobbyists say, but in what inventors say and other actors in the system, including litigators and economists and so forth. So I think it's about guaranteed that inventors will be witnesses, and not only at live hearings, but the Congress will amass a huge record, thousands and thousands and thousands of pages of input from hundreds and hundreds of people over and above those that testify at live hearings. So inventors will have a huge voice in this discussion. No doubt about it.
Okay, so that another question is on the China Select Committee I've had two offices tell me they're going to have a hearing on the reason that China is ahead of us in 37 of 44 technologies critical to our national security and our economic development. And as that relates to the patent system, and I believe that 101 is one of the biggest reasons that they're ahead. That hearing, I believe, will happen sometime this summer. What effect would that have on Tillis and the other people in the judiciary committees who are hesitant to actually do what's right and would rather take an approach that helps some but not all?
No, I think Tillis and Coons have exactly the right motives and the right bead on how to solve this problem. With regard to China, it's already been documented that many specific patents for inventions that were held invalid under the Supreme Court case law are eligible in China and also in most European countries. So this is a huge problem when you compare our technological leadership with the attempts of China to overtake us. So this is very much the focus of Tillis and Coons, and it has the potential to get the interest and focus of other members of the Senate and of the House. You know, I've testified myself twice, and I got no traction with the House committee at all until I talked about startups and about China. That was the first time anybody on the huge panel even looked up from their iPhone. So the threat of China dominating future technologies is the strongest motivation we have going for us. What Coons and Tillis need is allies. They need other senators, both parties, to come forward and say, this is a huge problem. We want to help you get this fixed. So yes, the China thing is big, and startups and new inventions is big for the benefit that they do to Americans and even to people in other countries. I think that's the most promising force, available in this fight with big tech.
Well, Judge,
Can I
you've given
jump in,
us-
Paul? I had a broader comment
Yep.
based on in response to that. Yeah, thanks, Judge Michel. Good point. We do have another champion in the House. Thomas Massey has a bill. I expect we'll have another one this year. And I think just this overall process, I'm reading some of the comments and the urgency to get on board and pass this. I just want to say, having worked now about 6 years on legislation, we are a part of that process, and whether our members come out in support of this or come out saying, no, this is not the right answer at the right time, we're part of that process. In 2025, we'll be involved as well. And I think what I see is a tension here, and Judge Michel, you're leading, and these champions, they are pushing I think the objective is helpful, and we can support the objective. But I see a tension here when I say the bill sponsors in their finding sections seek to prohibit patents on economic, financial, business, social, cultural, and artistic processes. And then in the text, we're having to interpret it almost the opposite. This is a part of the mess, the sausage making that's going on. They can't say, because there's just not enough support, whether it's from other members of the Senate, from the general public, from these activist organizations that are on the other side, to actually give patents on economic inventions and business inventions and social inventions. That all this is being debated. So we spent all the meeting here talking about the mechanics and the technicalities of the bill. The reality is there's a broader debate going on as to should we even have patents on this stuff at all? And I think by us coming out and pressing the leaders and pressing industry that claims to represent the inventors and asking the questions about the meaning of the text of the bill, we need to be pushing that broader debate and convincing people, like Paul has said, if China's out there leading us in 37 of 44 critical technologies, most of which could be classified, certainly by the Federal Circuit, under one of these categories, then that's the debate that I think we're having, that we're participating in here. And irrespective of whether we come out saying we've got to pass this bill, we've got to be all on board this bill, or no, this bill has some flaws that have to be addressed first. we need patents on these areas. I think that that's where we're moving the ball. We're persuading people that these technologies are really important areas for us to promote innovation in using the patent system, which we can't do today.
Well, I totally agree. And the number one problem, as I've said at the outset, is the eligibility law. There are other big problems in PTAB and lack of injunctions and so forth, as we all know, and some very bad case law in the Federal Circuit. But if we can't solve the problem of eligibility, nothing else will suffice. And you're certainly correct, Josh, that having a patent system at all is under attack. At all. There are a lot of people that say patents just raise prices, and consumers don't want prices raised. And a lot of politicians are worried about what consumers want or seem to want or are said to want. So there is a broader debate, and we need to win that debate and retain a vibrant patent system, as well as at a more detailed level, address problems like the lack of injunctions and the lack of broad eligibility. Absolutely.
Yeah, I was kind of on the same train of thought, Josh. And a question I actually had also was related to the same topic. If we were to compare this new bill and we would compare it to the eligibility requirements that China has, would they still, are they still more flexible? And even though we're trying to fix this, are they still able to get further ahead on the United States with us even having this new bill?
Well, it depends on a lot of things that I can't predict or control. The Chinese government is totally dominated by the Chinese Communist Party. They have a extreme level of control over all the business companies in China. Here, they're private companies. In China, everything is basically dominated by the government. So if they spend enough money, they may continue to make progress against us or overtake us, even more so. So solving the eligibility problem doesn't necessarily slow down China, but it will speed up America.
Well,
So Judge, in an
that's
effort for
good.
you to manage your time, and you've been giving us an hour and a half, which is we very much thank you for. I just want to say one thing. You're an old friend. You're one of the first few people I met here. I've read everything you've published. I have absolute respect for you. I'd like for you to take the last couple minutes here and explain to everybody why you think we ought to go behind this bill, and then unless there's some kind of emergency question, I think we're probably done.
Well, Paul, let me respond by saying that I don't argue that every member of this important group has to come out and support the bill. If an individual member of this group hates the bill for whatever reason, then of course I wouldn't expect him to support it. What I do hope is that the group as a group will not oppose the bill because of perceived imperfections, because the group is an important voice in the public debate over patent eligibility. And if the group as a group opposes the bill, its progress will be substantially hobbled. I have no doubt about that. Can the bill be improved? Maybe so. It's been the object of an extraordinary amount of work with some assistance from you and Ron and other very knowledgeable, expert, bright people. But it's, it's still a work in progress. Listen, every bill gets changed after it gets introduced. I was a staffer in the Senate for 9 years. Every bill gets changed multiple times along the pathway. So no, it isn't frozen in concrete. It's not uneditable, but if it's attacked on a fundamental level, it will die. So all I'm hoping is that the US Inventors doesn't feel that it has to attack the bill as a fundamental strategy to fix eligibility.
Well, thank you, Judge. I think everybody here, unless you want to stay longer, I'm sure there's a lot more questions, but you've been here an hour and a half. Want to respect your.
I'm
your
happy
time.
to come back anytime that you and Randy want me to on this subject or any other subject, because your group is a critically important group of people who actually do creative work. That's who's supposed to be served and protected by the patent system. And the country's gotten away from that. We need to get back to that.
Yeah.
So
Well,
anytime.
thank you so much for that. And you're right. And I don't know if all of our members realize this, but we are the only national group that really represents individual inventors and startups entirely. And we're the group, and we're it. And we've grown, we've become pretty large by now, but it's a big task ahead of us. And what's most important is that we're going to look very hard at this bill. We don't have an official position yet. We're going to look very hard at it, and we're going to look at what needs to be done, perhaps, to make it something we can fully support. But what's most important is we can't support something that we don't feel is good enough for the country and for the little guy. And we're going to work hard to make that decision, and we will let everybody know perhaps within a few days. So thank you for thank you for your participation, Judge. Thank you for everybody who attended, and we will let you know as we move along on this issue. So thank you.
Thank you all. Great to be with you.